Hi guys, it's Kathy. I hope you're doing well. Okay. Before we jump into OJ, I just want to show you something real quick. I don't know if you're following this trial at all. Chad Daybell. This is going to be a spoiler. So if you don't know what happened to Chad Daybell, just go away for 30 seconds and I'll be done. I'm going to show it now. So turn away now if you don't want to know and don't listen. Here we go. Jury sentences Chad Daybell to death. Wow. Oh my God, I wonder what's going to happen to Lori. We won't find out that for a while. All right. Back to OJ. Back to OJ. We're about to see how far we've gotten. This was us when we were young and innocent and stupid. This was video 1. Now we're going to scroll down and down and down. Oh, we are at video. I think we do still have like a few minutes left of this video. But basically, we are at video 162 today. We're creeping up on halfway. We're not halfway yet, but we're creeping up on halfway.
Document we were discussing that you sent for some time ago of an in-camera nature. If you have it on the bench, can't locate mine, maybe we could approach. I have a question about it.
All right, once you approach without the court reporter, please.
I'm sorry. Okay, question answered. May we approach the bench?
No tape yet. Nope, you did not miss it.
All right, ladies and gentlemen, we're going to take our recess for the afternoon at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you regarding the case. Do not conduct any deliberations until the matter has been finally submitted to you. And we'll stand in recess until 9 o'clock tomorrow morning. Detective Furman, you're ordered to return tomorrow morning, 9 o'clock. Thank you, sir. All right, you may step down. All right, we'll stand in recess. Good morning, counsel.
Good morning, Your Honor.
All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. Counsel, is there anything we need to take up before we invite the jurors to join us?
There is, Your Honor, partly because I personally represented to you yesterday that I had spoken with Max Cordoba, and because you may have heard reports that he gave a conflicting statement, I want the court to be reassured that I did indeed, about 2 weeks ago on a weekend, from Mr. Cochran's office, call or talk to Mr. Cordoba. Mr. McKenna was talking to him and interviewing. He called us. McKenna recognized his voice. They had spoken before. He handed me the phone just to say hello. As one Marine to another. I did that and handed the phone back. We reached Mr. Cordoba last night, and he said, yes, that's correct. I was confused when the fellow asked me the question. But the disturbing thing is that NBC would air that statement nationwide without picking up the phone to call either myself or Mr. McKenna, whom they're perfectly able to hound when they want something. They know where we are at all the time. They could have avoided this whole mistake. And that level of journalism is sinking way below what one expects of NBC. And I'm very upset about it. And I have reported it to Dateline, and I'm expecting a correction this evening when the matter is pursued. More to the point of this trial, Your Honor, you had ruled out the testimony of Mr. Coleman, who runs the ladies' wear shop next door. I believe that if one of the inferences that could be drawn from the conduct of Detective Furman was a deliberate racial slur, that should be a jury question and not for the court to rule out because there are other options.
Mr. Furman, would you step out, please?
Well, I would object. The court has ruled, and I thought the court had indicated a long time ago that once it's ruled, it doesn't hear.
Well,
I'm
Counsel,
not asking the
let
court
me-
to change its ruling.
Let me finish hearing from Mr. Bailey.
I'm taking a legal position, Your Honor, and because what we have is a letter from Mr. Coleman, in order that this subject can be properly scrutinized on appeal, in the horrendous event that should ever become necessary, I'm asking that you give me the opportunity to put Mr. Coleman on the stand out of the presence of the jury and have him tell you exactly what happened and the way it happened, so that a reviewing court can decide whether or not you've preempted the jury from deciding a question if the question as to what the conduct meant is a factual as opposed to a legal question. Second, Mr. Coleman corroborates Max Cordoba, because after Detective Furman called him a nigger inside the building and followed him out to the parking lot and did it again, Cordoba came to Coleman's place of business. Coleman remembers the incident and said, I had to calm him down. He was very upset, and he was very excited by the whole thing. Now,
Well, that's a different offer of proof.
I understand it. I'm bringing that to your attention because I learned it a short time ago when I called to see if Mr. Coleman would be available to come down and make an offer of proof on the record. That, to me, is the best possible form, and we think it would be worth the court's time to preserve it.
How about a statement in writing? I don't want to take up the court's time doing extraneous hearings all the time, counsel.
All right. Now, if you can enable me to understand, Your Honor, you have a rather elaborate statement on the first part. Cordoba, it seems to me, is a separate issue entirely.
I agree.
And his testimony would be relevant if Cordoba testifies, as he told Dateline he would last night, and is attacked on the ground that he made the incident up. Other than that, I'm not sure that a prior consistent statement would be admissible. But should it be termed a recent fabrication on Cordoba's part, and that's the drift I get from this side of the table, then the fact that he said that to Coleman hard on the heels, even if it's not part of the res gestae, would become admissible under California law. I don't think that question is going to be presented to you as to the Cordoba part, unless and until that attack is made. I do think that I would like a better form, and if you're suggesting I rewrite or we put together a new, more formal statement, since those were all Mr. Coleman's words, pinpointing the issue that we wish you to take another look at, perhaps. I'll be happy to do that rather than take up the court's time putting him on the witness stand. I don't think it would take long, but I'll be happy to pursue that.
All right, I think you have the direction from the court.
Okay. Now, in addition to that, Your Honor, we have a case that we would like the court to consider. It is a court case that was thrown out because Detective Furman lost a door in which a bullet hole was supposed to be, called the Gould case in the Superior Court. We believe that his conduct in that case is relevant to this one. We're going to ask you to take another look at the Britton case on which you previously ruled, perhaps with some additional facts. Beyond that, Your Honor, the phones are ringing and ringing hard. People calling in who watched the detective and now wish to offer evidence contradicting his claims. And as these people come up, as rapidly as I can, I will submit them to the court as a proffer, the way I did originally, and then await your direction as to what, if anything, must be turned over. But this is an ongoing process, and I expect it will continue for some days.
All right, thank you. Ms. Clark.
I think I'd like to play a tape for the court. Because not only did Mr. Bailey make a direct misrepresentation to the court yesterday, he's done it again this morning. And I think that as I said yesterday, as I predicted, the tape would be very illuminating and provide the court with some very graphic evidence of the way counsel takes his role as an officer of the court so lightly. I want to play this tape now so that the court will be reminded of exactly and precisely the language Mr. Bailey used yesterday when he sought to misinform and mislead this court as to the nature of his contact with Mr. Cordova.
All right, Ms. Clark, what is this a tape recording of?
I'm sorry?
What is this a tape recording of?
His appearance in court yesterday, in which he stated to this court, in which he stated to this court that he had a conversation, Marine to Marine, with Mr. Cordova, and that Mr. Cordova told him, not Mr. McKenna, him, the statements that he later reported to this court.
You're referring to the comments by Mr. Bailey at 18606, beginning at line 15.
We don't have a transcript, Your Honor.
You know,
Yes, you do.
$606.
18606, starting at line 15.
You okay, this?
I'm sorry? Mr. Carpenter?
Mr. Darden and Ms. Lewis about this incident, and they shut him off. They said, we're only interested in what Ms. Bell said. And that's what he will testify to. And Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever. As far as discovery is concerned, there is no written statement. There are no notes that I know of. And I heard about this because he called us wanting to make it known that these people had tried to suppress this information. I spoke to him personally. I don't ever take notes, and I didn't on that occasion.
all right. That is not what Ms. Clark says. I said I did not claim that he related the incident to me. I said I spoke to him, and I have no doubt that he'll appear, and I don't have any doubt.
All right.
This is the kind of nonsense that gives lawyers a bad name, Your Honor. You know, it's very clear what he said to the court and what he was intending to convey. He was intending to convey to the court that he had personal knowledge of what this man said because this man said it to him personally, Marine to Marine. And now he's standing up and hair splitting with us. I never said he said this to me. I just said he spoke to me personally. That's nonsense. That shows you what we have over here in the way of ethics on this side of the table. They'll get up and they'll misrepresent to their heart's content until they get caught. And then they have excuses. And then they start splitting hairs. And then they have, well, this means this. And oh, no, that means that. I feel like we're in Alice in Wonderland. We've got Jabberwocky here. Nothing means what it says it does. No means I don't remember. I don't remember means no. Same thing. Now it's coming out of the mouth of Mr. Bailey. But that's exactly what we can expect to happen when the witnesses take the stand. If we rely on his offers. And we have not been able to reach Mr. Cordova, we need to talk to this man personally. I can assure the court, absolutely. No one cut Mr. Cordova off. No one refused to listen to him. As a matter of fact, Mr. Darden kept it, tell us more, tell us more. Please, is that all you have? Is there anything else you want to tell us? And with respect to Mr. Cordova's prior statements, they've been aired on national television. I mean, if Mr. Bailey doesn't know what he's said before, I guess he's never turned on his television set. But they're a matter of record that all the world has seen. So if he is now claiming to have heard something as volatile and inflammatory as what Mr. Bailey is representing, we do have some serious impeachment. But no one cut that man off. We did not have the opportunity to speak to him, so we do not know exactly what he has, what he's going to say at this point. I certainly do not feel comfortable accepting anything that Mr. Bailey offers to this court, especially in view of what we've heard. And I would like to play the clip for the court from Mr. Cordova, because Mr. Cordova, when given the opportunity to say, I spoke with a member of the defense team, I spoke with an investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Bailey, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
I object to the lack of foundation for this tape. Excuse me, don't play the tape while there's an objection. If Ms. Clark is going to take the stand and authenticate the tape, let her do it. But tapes are not self-authenticating. We've had no chance to see it, as you always require, before we're allowed to show anything to you. And I'd like to know where it came from and what it represents.
It's not before you can show it to me, before you can show it to the jury.
Right.
All right, Ms.
I'm
Clark,
just
what
showing
is
you to
this?
the court, if you please, Your Honor. It's self-authenticating. The man on it says he's Max Cordova.
Well, no, we've gone through the self-authenticating argument before, which I did not accept, if you recall. But being that as it may, what is this?
This is the tape of an interview with Dateline, which was conducted yesterday after Mr. Bailey made his representations that he had spoken to Max Cordova. After he made those representations in court, Dateline went and interviewed Max Cordova and asked if he had had an interview with Mr. Bailey, Marine to Marine. And Mr. Cordova said, no, I did not.
Which answer is correct?
All right. Do you have an extra copy, by the way?
He's got a new partner to solve this mystery. All new.
That's Bill. That's Bill Cosby, Ms. Clark.
I'm aware of that, Your Honor.
All right.
We're not offering Bill Cosby at this time. And while he's doing it, Your Honor, if I may request that the notes Mr. McKenna surely must have taken as a responsible investigator of that interview that we now learn occurred, which obviously Mr. Bailey did not want us to know yesterday. We want the notes of Mr. McKenna's interview with Mr. Cordova yesterday.
No, Sean.
You know, it's interesting that other states have rules of reciprocal discovery that require at least some offer or indication of anticipated testimony in their reciprocal discovery statutes, which is something California does not have.
I find it interesting, though, that it would appear the investigators for the defense in this case have prepared reports and taken notes on all other witnesses, but surprisingly, nothing on this one.
Well, I assume that's something you'll cross-examine on.
Probably fair to assume. Well, at least Mr. McKenna, a witness at the very least.
And Ms. Clark, who tape recorded this for you?
Susan? Media Relations Department did, Your Honor. After contacting Dateline to find out when the interview was conducted.
And are you representing to the court that this is a videotape of the Dateline broadcast? When?
Last night, Your Honor. This is a videotape of the Dateline broadcast last night, an interview that was conducted with Max Cordova after Mr. Bailey's representations to this court yesterday concerning his contact with Mr. Cordova.
Is that Max Cordova?
That he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever.
No, I have not talked to FB Bailey.
If you believe Max Cordova, and the defense hopes you will, then Simpson's defense team has some explaining to do. Because today, in our exclusive interview, the ex-Marine and potential witness said he didn't know what F. Lee Bailey was talking about. That if he'd spoken to the famous attorney, he'd remember, and he doesn't.
Never talked to him. No.
You know who F. Lee Bailey is?
Yes.
Pretty distinct fellow.
Yeah.
Pretty distinct voice.
Correct.
So you haven't talked Marine to Marine to F. Lee Bailey.
No.
But Cordova told us he does remember talking to Furman, and what he now says Furman told him ignited a heated debate today in the courtroom.
Max Cordova wanted to tell Mr. Darden and Miss Lewis about this incident, and they shut him off.
By the way, that representation will be disproven as well. Now, Mr. Cordova had the opportunity to say, well, yes, I had some brief conversation with.
OJ got demoted. OJ got demoted like Marsha did the other week. He's drinking out of a Dixie cup. Good.
Mr. Bailey, but we didn't discuss the content of my testimony. Or yes, we had a brief contact. He said hello to me. Mr. Cordova said none of the above. He had the opportunity as well to say, Mr. McKenna spoke with me. I know he's a defense investigator. He did not say that either.
All right, Ms. Clark, let's assume, for the sake of the argument, that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think the witness should be precluded from testifying. I think that Mr. Bailey should be cited for contempt and fined substantially. As an officer, an officer of the court, he has lied to this court. He is impeached by his own
Your Honor, and I ask
witness.
that you put a stop to it. Either
Mr.
put
Bailey.
Cordova on the
Excuse
stand
me, Mr.
or
Bailey.
stop her from
Mr.
taking
Stand
Bailey.
up and speak when it's your turn.
Mr. Bailey, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I
finish
think
your
that what has occurred is very serious. And I think that the interview with Mr. Cordova makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Bailey got up to represent to the court this morning. Mr. Cordova was confronted with the statement that Mr. Bailey made, that they spoke. He said, no, we did not, and I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
All right, thank you, Ms. Clark. Mr. Bailey, do you wish to respond?
I do, Your Honor, and I do not appreciate being called a liar in any court, and I will ask at the proper time for correct action to be taken against the offender. The proper way to proceed.
Mr. Bailey. Hey, Mr. Bailey, you're a liar.
If there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence. What they eliminated from the tape that I saw on NBC News this morning was that Stone Phillips said, why didn't you mention these things before? He said, I only give very narrow answers to every question. As he explained to Mr. McKenna last night, he did not have an interview with me, nor did he tell me his story. When he was talking with Mr. McKenna in the office, Mr. McKenna handed me the phone to introduce me, and I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know.
Liar. He said he has never spoken to you. You said you had this conversation with him. He said he has never spoken to you. So you can say whatever you want about Marsha, but those two things happened, sir. Liar.
Know that it's painful. And he said, I'm willing to do it. And my comment to the court was in response only to the unfounded, irresponsible, and false assertion by Ms. Clark that Cordova would never appear. She had no basis to say that whatsoever, as she has just shown with her own videotape. Now, I expect NBC to correct it, and somewhere down the line, I hope that this court record is made plain. Mr. McKenna is seating right here, and he is available to get on the witness stand and assure the court that Max Cordova said last night, okay, I now remember I spoke briefly on the phone. That's not an interview. Phillips could have saved himself some embarrassment if he'd bothered to pick up the phone and call me. NBC always finds me when they want to.
I am concerned, though, Mr. Bailey, that the statement, I have spoken with him on the phone personally, Marine to Marine, that sort of connotates something more than just, hi, how are you? I'm glad to talk to you.
I don't understand why you're concerned. You raised no question about what was said. I was simply, if you were reading the transcript correctly, giving you my assurance that I expected him to appear when called, that he was under subpoena, and that I did not think he would vanish, and that I had spoken to him and received an assurance on that alone. I do not interview witnesses. Good lawyers generally don't. They might.
Stop. Now you just lied again. Before, you were just seconds before, you were saying all you did was say hello to him. Now you're saying that you made sure that he's going to come to court. You assured that he's going to be here. That's more than just hello. So what is it? Which is it? Did you never speak to him? Did you just say hello to him? Or did you have a conversation Marine to Marine with him to assure he would be here? Which is it?
Might be in a position of having to testify if the witness were to accuse them of something or tell a different story. Mr. McKenna is employed for that purpose. We happen to be in the same room when Cordova called us, as his phone record will show, if he has made the call from a private phone and was billed for it. Now, you're perfectly able to explore this right now with Mr. McKenna, and I wish you would. And if you read the transcript carefully, I was reacting to the only thing that concerned me, because an offer of proof is an offer of proof, and the court has to accept it as that. But the court might be concerned that if cross-examination were put forth and the witness never appeared, that the damage would be done and you couldn't unring the bell. And it was my purpose to assure the court that I felt this fellow would appear based on his statement to me that he would. And that's all that transcript says, and you can't read it any other way. If you've got a contrary impression, I'm...
Okay, so then that's what it is. You had a conversation with him. You had a full conversation with him because he assured you he was going to come to court.
Sorry, that was not my purpose. I wanted you to know that I believed he would appear or I wouldn't put the questions. And that is the sum total on the subject.
All right. Thank you, Mr. Bailey. All right, counsel, we have an interesting situation here, not unexpectedly. Counsel, what we're going to do with regards to Mr. Cordova. Ms. Clark, where does Mr. Cordova reside?
I'm sorry?
Where does Mr. Cordova reside?
He's not in the state, or he wasn't last night. We were unable to contact him.
What state does he reside in, Mr. McKenna?
He's not in California, I don't believe today. He resides in Bellflower, if that's a town. He has a subpoena.
When did he leave?
I believe he left either this morning or last night.
And when did you speak with?
I spoke to him.
All right, Ms. Clark, I agree with Mr. Bailey's comment that television news broadcasts are not bases for the court to preclude at this time the offer of Max Cordova as a defense witness, unless and until I hear testimony from Mr. McKenna and Mr. Cordova himself regarding these issues. I think you agree with that. So at this point, I'm going to preclude any cross-examination regarding anything with regards to Max Cordova, which I had previously done, but I'm going to extend that prohibition through the remainder of Detective Furman's testimony. Under the California Evidence Code, a prior inconsistent statement may be offered as long as a witness has not been released from the requirement of providing further testimony under 770 of the Evidence Code. So if it should transpire that Mr. Bailey is correct in his assertions, then perhaps we will hear from Max Cordova. But unless and until I'm satisfied that the offer of proof there is a sound basis for it, I don't believe Max Cordova will surface. But I'll determine that at a later time.
Okay, thank you, Your Honor. Mr. Dart needs to address the court on the matter of Alwyn Martin.
I was going to ask whether I could ask questions about Alwyn Martin because they had a tape recorded interview with her last night, we're given to understand. But I would like a clarification of what the court is saying. You don't know whether Max Cordova is going to surface because you don't know if he will repeat what he said on television?
No, what I'm saying is that as far as this controversy
Yes.
that has since arisen, I'm not going to allow any cross-examination with regards to anything Max Cordova might or might not say unless and until we hear from him first, because there are some issues we need to resolve before he gets the witness stand in front of the jury, is what I'm saying.
Now, he's in New York for 4 days, I'm told.
Well, I suspect the defense case won't start anytime between now and next week.
Are you saying that you will postpone examination of Detective Furman on the Cordova issue until the defense case has begun?
That's correct.
Well, I strongly object to that, Your Honor. You have the power to get Cordova in here while the prosecution's case is going on and hear from him and make your preliminary findings. But to put it that far down the road is completely unfair in the cross-examination of this critical witness.
Well, counsel, I didn't create this problem.
I didn't create it either, Your Honor. We interview witnesses, we make proffers to the court, and that's all we have done. We subpoena witnesses. That too. I didn't interview him for Dateline or ask him to talk to Dateline. Nor did I confuse him as to whether or not he'd ever talk to me. What are we being penalized for? I don't understand.
You're being penalized at this point merely under the procedure of the California Evidence Code, which says prior inconsistent statements can be offered in one of two ways. Either the witness is confronted or the witness is still available to be cross-examined. And that's how we're going to do it. Thank you, sir.
All right, no more objection, please.
Noted. Mr. Darden.
Good morning, Your Honor. Your Honor, the people would like to lodge a 352 objection to the admission of any information relative to Detective Furman's contact with Alwyn, A-L-W-Y-N, Darla Martin. Ms. Martin was the victim of a carjacking on May 20, 1993. During the commission of that assault and robbery, she apparently was stabbed. She was taken to the hospital where she was treated. She was taken to surgery. 2 days later, Detective Furman visited her at the hospital, as I understand it. When he walked into the room, Ms. Martin's boyfriend was there. Ms. Martin is Caucasian, as I understand it. Her boyfriend at the time was African. I think he was British, actually. So not necessarily African American, but of African descent. Detective Furman met him. They shook hands, introduced themselves, and Detective Furman had a conversation with Ms. Martin relative to the description of the carjacking suspect. Last night, one of our DA investigators, Brian Hale, interviewed Ms. Martin. Ms. Martin could point to no racial epithet uttered by Detective Furman. She could point to no racial slur. Detective Furman did not tell her that only blacks or African Americans commit carjackings. Detective Furman did not tell her that he disliked interracial couples or that race mixing was a crime against nature or anything of that sort. We've reviewed the file, the investigative file in this case. There's nothing in the file to indicate that Detective Furman harbored any type of hostility or animosity toward Ms. Williams or her boyfriend because of their relationship. There's no evidence. I'm sorry, Martin. There's no evidence, no indication, no firm evidence, no firm allegation by the witness, Ms. Martin, that Detective Furman has done anything but act professionally. I don't know why the defense wants to introduce.
I don't know why Jordan's speaking. How come he's allowed to speak right now?
This incident or this contact. But I can assure the court that there is nothing here which suggests that Detective Furman harbored any racial animus or bias against Ms. Martin or her boyfriend because of their interracial relationship. I'm at a loss. to explain or understand why they want to introduce this. It shouldn't come in. It just shouldn't come in. I'm sure that once counsel begins asking his questions relative to this issue, and once he puts his own spin on it, that perhaps he can somehow transform it into a racial issue. But based on our conversation last night with Ms. Martin, there is no racial issue here. There's no evidence at all that Detective Furman acted in any way other than as a professional police officer.
All right, Mr. Bailey.
First of all, I'd like to hear the tape. Mr. Darden has chosen not to confront the offer of proof in any way. You were never told in writing or in any oral description by me from this podium that racial epithets were used or any of the other things he's attempted to negate took place. What you were told was that Detective Furman was assigned to investigate a stabbing and a robbery of an automobile. That pursuant to that assignment, he came to the hospital to interview the victim, who had been injured in the stomach with a sharp instrument. That she told him the assailants were white, that he suggested that they may have been light-skinned blacks. And when she refused to budge on that issue, he left the room, filed no report, and never returned. That was the offer of proof. I have not heard that contradicted. But because we're having these problems, I would suggest that the court listen to the tape that was made last night and that we make it part of the record. If you're relying to any extent on his interpretation of what he thinks someone else heard from Ms. Martin, the court needs to hear it directly. And then if the offer of proof is somehow improper, you have a chance to catch it right now. But the tape is the best evidence, not Mr. Darden's spin on that tape. And I think we should hear it.
Mr. Darden.
I'd like to hear their tapes, Your Honor. Our tapes are impeachment evidence. I don't know what Mr. Bailey has been reading, but apparently he hasn't read the complete police file in this case. Detective Furman did file a supplemental report. And not only did he file a supplemental report, he also took to Ms. Martin a mug book containing many, many white arrestees and potential suspects, all Caucasian. Detective Furman did his job, Your Honor. Now, he questioned Ms. Martin apparently about her description of the suspect, as any detective would do. Where's the racial issue? Yeah, there is none. Mr. Bailey perhaps should get the rest of the police file on this case. And once he does, he'll see that Detective Furman attempted to run down partial fingerprints recovered from her vehicle. He took her mug books. He looked at other reports, okay, to see if there was some type of MO between this carjacking and others. He did everything a police officer is supposed to do in a case like this.
Have that file here, or a copy of it.
I have a copy of the supplemental report.
Your Honor, might I point out that Ms. Martin called Detective Tapia, the West Los Angeles Police Department, to ask for the report, and he sent her 2 pages and said that's all there was. Furthermore, I'm startled to learn today that the prosecution has so many facts on the Martin case. They were very silent about them yesterday when we first discussed this issue. Perhaps this is something that Detective Furman never mentioned until after we talked about it.
You know, we weren't particularly concerned about the Alwyn Martin case, Your Honor. Why should we be? There's no issue of racial animus contained in this case. At any event, before counsel stands before the court and makes these allegations of this nature, he ought to check out the facts. He ought to know what he's talking about. In addition, Your Honor, LAPD does not turn over unsolved supplemental investigative reports to victims or to anyone. This case is not closed. This case is still an open case. And I would ask the court to direct counsel not to distribute the supplemental report to anyone, and that no copies be made as well. There was a partial fingerprint recovered from the victim's vehicle, which at some point may be matched to a particular suspect or defendant.
Nan, where were you in 1993? Did you stab somebody in the belly and take their car?
In addition, Your Honor, when, as I understand it, when Ms. Martin contacted Detective Tapia at West LA detectives relative to this report, she mentioned to Detective Tapia that Detective Furman had done a good job and that he had acted as a true professional during the contact that she had with him. If I can stay further, Your Honor, I don't want to have a mini trial on racial issues, Coleman and Martin and Cordoba and all of these other people. I don't want to have to call 25 witnesses in this case just to rebut these
Not yet,
malicious
Kelly,
allegations
not
the
yet.
defense has launched against Detective Furman. And we shouldn't have to. At some point, this becomes cumulative. At some point, 352 has to come into operation and cut the defense off. Okay. I mean, this is ridiculous, and it's going to result in a mini trial. And the jury shouldn't have to sit here an extra 2 weeks, and I shouldn't have to sit here an extra couple of weeks to litigate these collateral issues. Now, every contact everyone had with Detective Furman, is a case of racial animus or reflects some racial bias on Detective Furman's part, Your Honor, especially this one. It looks like good police work here. Nothing more, nothing less.
If it pleases the court, would have been much nicer if Detective Tapia had been truthful to Miss Martin and said there is more of a report that I can't give you. She was given to understand that the 2 pages were all that ever happened, and from that we do quite properly an inference that there was no follow-up. But all that aside, Miss Martin came to us because of Detective Furman's conduct. She described it as we have described it to you. That was the offer of proof in camera, and that's the offer of proof as it exists today. If she made statements about Detective Furman being a nice fellow, doing a good job, that's perfectly available for impeachment. But the evidence about trying to suggest that a white suspect, very clearly white in this report, might have been a light-skinned black, was what brought the whole matter to your attention to begin with. And I've not heard that controverted yet. I would like to have marked, however, Your Honor, because the subject is still very much alive, a document that just came over the fax from Phil Coleman, and I'd like Your Honor to read it.
I'm not going to deal with Mr. Coleman at this time, Mr. Bailey.
It deals with Mr. Cordoba.
That's a closed issue at this point.
Cordoba is a closed issue until the defense begins,
Correct.
and we're not allowed to address Your Honor on it again.
I'll allow you to, but not today. Don't press it. My concern, counsel, is now I have a report that's dated June of 1993, which clearly indicates that the suspect was white, clearly indicates that the suspect stated the male white suspect. It clearly indicates a suspect description. It's signed by Detective Furman. It indicates a inquiry into other possible connections that might be a factor in the robbery. Indicates the recovery of the vehicle, the garnering of fingerprint evidence, and the detective taking mug books to the victim for possible suspect identification. This is contrary to the offer of proof.
And withheld from the defense.
Well, this is a defense witness that was
Defense
brought.
witness has no access to police reports, particularly when she's told they don't exist.
All right, I find the offer of proof to be clearly contradicted. Prosecution objection will be sustained.
Your Honor, if I can be heard, relative to the issue of the follow-up
And I'll mark
investigation.
this as Court's Exhibit 7.
Your Honor, would the court kindly order defense counsel to return the supplemental reports to the court? And would the court seal the supplemental reports?
Yes.
May I have this document marked for identification?
You may. I will read it. Hand it to the clerk. Let's have the clerk make photocopies for counsel.
Still a liar.
All right, any other comment before we invite the jury to join us?
Yes, Your Honor.
Me first, Your Honor. He's a liar.
A couple of matters that may arise, I thought I would preview them for Your Honor, rather than have to go to the bench in the middle of cross-examination. I have purchased a light which I believe is identical, or at least very similar to the one that Detective Furman has described repeatedly in his testimony.
You described it as a AA, 2AA mag light, which that appears to be.
Yeah, and I would simply like to know from him before the jury comes in whether it is a replication, so that it would be fair to use it in cross, in asking where he was holding it, where it was kept. I also have, which does not purport to be the same size or manufacture, a brown leather glove in a Ziploc bag that I would like to refer to in cross-examination without suggesting that it be marked as evidence unless the prosecution wishes that be done, as with the flashlight. The third item is I intend to ask Detective Furman to name his 3 best friends. And I intend to do that in reliance on your ruling that
I was just thinking that if he plans on holding that little tiny light up to make it seem like it was so little that he couldn't have seen anything with it, or he's just wrong. Those flashlights are awesome. They gave out so much light. And the jury has to know that, right?
was a proper question for Rosa Lopez. We would like to talk to those friends.
Where exactly?
Ms. Clark?
Where?
Certainly.
I mean, they were great. I used them too because I had 3 little kids, and I couldn't you can't wrangle 3 little kids holding this great big mag light when you're going places. You need something that can fit in your hand as well as a small child's hand in your hand. And they were great. They were amazing.
If it please the court, we tried to locate a copy of the Help Furman letter that was referred to in the testimony. We have been unable to procure one. We have its contents described in this article, which was sent to us from Oklahoma. And as I understand it from Mr. Furman, he has some knowledge of the letter that went out. I believe that if he does not have a copy with him, his lawyer, Mr. Tortolo, who, as we speak, is, I believe, on the 12th floor, prepared to watch his testimony. And I would like to request that the prosecution attempt to make that letter available before the cross is concluded. I would like the court to take a look at the basis of my request, which is this article.
Well, I think if Mr. Tortolo is on the 12th floor, I could ask the public information officer to go up there and see if Mr. Tortolo has a copy of that available.
I think we just asked him.
Ms. Hazlett? Thank you.
I have given a copy of the article. Please, the court, to the question.
With respect to the flashlight, Your Honor, no objection. With respect to this plastic bag, this is ridiculous. The Ziploc bag, for which there's no there is no connection to this case. A leather glove of a different size, a different color, a different make, a different style that has no relevance to this case either.
May I see that?
Yes.
Thank you. When you say different size, what do you mean, Ms. Clark?
Obviously smaller. So my size. And I think council even conceded that it's a different size. This is, under 352, there is no valid probative purpose to this. I'm sure the court knows that what Mr. Bailey again intends to do is make another inflammatory argument with no evidentiary basis whatsoever in an attempt to confuse, mislead.
It can't be. It can't be, man. Man, there's just no way Dearden had OJ try that glove on. There's no way. It has to be the original glove. I'm going with the judge can't let this glove into evidence or even as a prop. He can't. And there's no freaking way that's the glove that Dearden told him to put on because it's so tiny. No, because that would have been it wouldn't have been as big of news if he tried on a tiny glove and it didn't fit. No, I'm going with no.
And deceive this jury. This has no part in any search for the truth. This is a fantasy woven by the defense, for which there's no evidentiary basis, no logical or factual connection to this case.
Let me ask you this. What is the glove size that is on the glove that was recovered at Bundy?
Extra large.
Glove there is a Brooks Brothers size small.
Right.
They're out of extra large, Your Honor.
Not only that, but the glove in issue is an Aris, and it is not a Brooks Brothers. Can't even tell if it's a man's or woman's glove. Size small. I guess it's Mr. Bailey's. I don't know what the relevance is to this case, Your Honor. I can't see any possible valid evidentiary purpose for the admission of such an item that bears no resemblance to the gloves in this case, or a Ziploc bag that has no, absolutely absent from this case, no such evidence in this case whatsoever. And I think that the court should prevent these kind of theatrics that are misleading and inflammatory and deceptive in front of this jury.
What's your comment on the letter regarding Detective Furman?
With respect to that, I'd object to the admission of the article. With respect to the letter itself, I have a real difficult time seeing the relevance of that, Your Honor. Mr. Detective Furman has sought legal assistance for the purpose of defending himself as a result of the malicious attacks that have been made on him by the defense. In that regard, his lawyer attempted to defray some of the costs of his legal expenses. This was not a letter drafted by this witness, by Detective Furman. It was a letter that went out by his lawyer that this witness apparently is not even familiar with enough to say what's in it or not in it. So that alone, I think, should preclude the use of it. I don't see its relevance in this case. It does not show any financial interest in the outcome of this case that would be relevant to bias. So I think under 352, that letter is of no probative value at all. I should also indicate that Mr. Bailey has given us no proof, no offer of proof even, as to how Detective Furman, which I'm sure is the inference that he wants us to draw, put the glove that he found at Rockingham into a plastic bag. There's no offer of proof. There will never be any proof. There will never be anything but Mr. Bailey's theatrics, dramatic, albeit eloquent statements to this court that are absolutely empty of any evidence or any factual support. And that is why he is seeking to take a different pair of gloves, different style, different size, in a Ziploc bag that this case does not contain. There is no Ziploc bag in evidence in this case. He's manufacturing evidence. He doesn't like the truth, so he's manufacturing his own. And that's what this is all about. And that's why this is the kind of thing that should not be permitted. May I have a moment, Your Honor?
Certainly.
let me ask, is the court inclined to allow in a newspaper article, or is the court going to seek to allow, is the court going to allow counsel to use the actual letter,
I don't know yet.
or neither?
I don't know yet.
We don't know yet. I think that as far as the letter goes, I think we've gone as far as we need to go. Detective Furman indicated he was aware of the letter. He did not draft it. He's unaware of the precise contents of it. It was an article drafted by his lawyer. But counsel has received the admission from Detective Furman that he saw it.
He knows what was in that letter. He wants money from people. Come on.
Yes, with respect to the letter, I think, no, I've said it. With respect to Detective Furman and the plastic bag and the glove that counsel now wants to admit, there is absolutely no evidence that Detective Furman put anything in any plastic bag on any time relevant to this case, June 12th, June 13th, or June 28th, or July, August, September, October, none. And so there is no valid purpose for the admission of that non-evidence.
All right. Mr. Bailey, any brief response?
May I respond to that, Your Honor? I take it there's no issue as to the three good friends. Just a couple.
Yes, no, I'm sorry, I forgot to address that. Allow me, please, counsel. With respect to the three good friends, Your Honor, number one thing, we have a privacy issue as to those three people. I wonder if it's fair to have their names aired publicly for no valid purpose. With respect to the cross-examination of Rosa Lopez, I mean, this seems to be this kind of like a petty tit for tat. You did it, so we get to do it. They obviously don't understand. Mr. Darden was cross-examining Rosa Lopez because she claimed to have witnessed something very important, very significant concerning this case. And obviously, it would be logical for one to expect that she would tell that very significant observation and experience to her closest friends. And so that went to an important area of impeachment. What is the valid purpose of inquiring of Detective Furman who his best friends are? There is none. This is just a petty, vengeful kind of tactic employed by the defense. If the court is inclined to allow for this kind of nonsense, then at least allow Detective Furman to write them on a piece of paper and allow counsel to see those names. But I think there is no valid purpose for this. I really think it's just a petty, ridiculous kind of form of payback by the defense. There is no valid evidentiary purpose to it, as there was in the cross-examination of Rosa Lopez. I would like for counsel to perhaps give this court an offer of proof as to the relevance of Detective Furman's three best friends.
But I suspect Detective Furman's three best friends would be proud to be stand up and be counted.
I'm sure they would, Your Honor. I just want to give them the option of doing so. But if counsel wants to, you know something, as the court is well aware.
Why don't you ask Detective Furman if he has any objection?
I can.
And I would suggest, this is something that in most cases they're entitled to look into. Obviously, the people you want to talk with are the people who know the person the best.
Right.
If Detective Furman has no objection to revealing that privately to you and to counsel for investigation purposes, then it's a non-issue.
I'll be glad to handle it that way. It's just that, we are all sensitive to the privacy issues that have been
Indeed.
foisted upon us, and I just
Indeed.
don't want to do that without anybody's say-so ahead of time.
All right, well, let's pursue it that way.
All right.
Your Honor, the letter Mr. Bailey alluded to a moment ago is here, and the clerk is making copies of that letter.
All right, thank you. Mr. Bailey?
Let me address the other issues and save that one until I get the letter.
All right.
To actually see it, the transcript, if it pleases the court, page 18, 750 and before shows that the witness knew about the letter. It was unclear as to his understanding of all of its contents. The flashlight is solved.
Yes.
Let me state very clearly, and I should point out that if Ms. Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory. But Marines, if it please the court, have a habit, most of them acquire, as to where they carry things because of the nature of their duties, drills and activities, and the nature of the issued garments that they wear. The prosecution has opened this door rather deliberately, knowing full well that there would be questions as to whether or not the someone, and there has to be someone, who transported that glove to Rockingham could have been Detective Furman. They were at pains to have Detective Phillips say that he never wore a coat or almost never wore a coat, suggesting that he would not have had the means to conceal the suspect glove had he acquired it. A generous offer would be to use both, the bulk of which exceeds the large glove that will be in evidence if they ever get through testing. The plastic bag, I think, is reasonably similar, and the witness can tell us, to those contained in the homicide kit in the car that he was driving that night, or riding in. The rubber glove, which is here for a different purpose, is similar to the one that we have seen on Detective Lang and that Detective Furman said was in the homicide kit and available to him. We have suggested that he has described with great differences a key trip to the body of Ronald Goldman. We suggest that most killers don't leave one glove at the scene and carry the other one to private property under any circumstances, and I suspect that every detective who's asked if he's had that experience will have to say no. So the likelihood is that when the killers left the scene.
So what you're saying is, A, there are killers that on purpose just leave gloves at the scene, you know, with all their DNA all over them. And B, killers don't, in the heat of the moment, drop things as they run away. Come on. This whole hour and almost 4 minutes right now has been them treating us like we are stupid.
Both gloves were there or both would have been taken. You have seen that the one glove, which is admitted in evidence, was under some leaves and not easily visible until the leaves were poked back. Detective Furman described that as leaves cascading down over the glove and partially blocking the view of it. Assuming, since that glove is right against the fence, that the other one was seen several feet away from the vantage point on the north side of the fence in the shrubbery, where it would not be immediately visible unless specifically looked for with a flashlight. If that was spotted, even with this little light, which throws a pretty good spot for a short distance in darkness, how was it transported to Rockingham? Certainly the prosecution is going to ask that question. If it were placed in a bag, which would explain the reason that it didn't dry, and we will offer evidence to this court that had it been sitting out in the air at 60 degrees under the conditions which existed that night, it would have dried, and that will be given by someone who has seen the glove and the amount of blood on it.
Nan, you would know better than me because you're a nurse. But blood, I mean, water dries in 60 degrees way faster than blood, especially if like they hit an artery, which they obviously hit an artery. They said that, you know, that Nicole was in a pool of blood. I think that was flowing down the sidewalk. So, I mean, I've dealt with my own blood just as a layperson, not as a nurse, and it doesn't dry like water. So if that glove was saturated at what, 2 a.m., I can't see it being bone dry at 6 a.m. or when, yeah, they got there around 6 a.m., right? Wait, I'm trying to think of the timeline. Let's go with worst case scenario. Let's go with she was murdered at 10 p.m. And then they they got to the glove at Rockingham. I'm trying to remember. Was it 2:09 is what, was it 2 a.m.? 5 hours. Let's just say 5 hours, Nan. If a glove was soaked in blood for 5 hours, 60-degree weather, but it's dark outside because it's in the middle of the night. There's no sun beating down on it. Is that glove still going to be wet and sticky at 2 a.m. when the police get there? Or let's just say 5 hours later. I need to stab somebody quick with a glove and find out. This is academic at this point. I have a list.
And is an expert in such matters. So, one way to explain its failure to dry would be to have it sealed off from the air. Detectives frequently, as we have seen in this case, collect evidence in plastic bags, something you are never supposed to do if you're dealing with blood, because everything that plastic bags do, as you will recall from an incident in the courtroom, to bloody objects is bad for evidentiary and detection purposes. Marines tend to carry things in their socks, the same way some detectives carry an ankle holster for a backup weapon. This package could easily have been kept in a man's sock, short or tall, for the length of time that would have been necessary from the finding of the glove, if it occurred when we believe it did, on his visit to the North Fence, described in dramatically different ways on 2 different occasions, in ways that can't be reconciled. It could have been concealed up to the time that he bolted out of the house without telling anyone and making sure everybody else was occupied, and for 15 minutes did something which we believe explains the presence of the glove, the blood, and the Bronco, etc. And we ask Your Honor to note that this man said that for 5 to 7 minutes he investigated the side of the house, wondering who dropped the glove and where he had gone, and failed to notice a set of steps and a door leading into the house. If that does not contradict any possibility that he occupied his time, as he says, I can't imagine a stronger contradiction. A door is hard to miss. And Mr. Furman has experience with doors, as we will show you in the Gould case. Now, based on all that circumstance, I think it's fair to ask Detective Furman if it would have been possible for him to put a glove in a plastic bag to which he had access and to stick it in his sock and to later pull it out and dispose of the plastic bag. Not a complicated question, not one he'll have trouble understanding, but a fair question, it seems to me. Because at the end of the day, the jury is going to have to decide between the choices given them, whether this defendant jumped over a fence or did something unreasonable and dropped a bloody glove on his property, whether a killer wishing to divert the police, and if this happened, he was eminently successful, from any attention to him, deposited the glove simply by throwing it over the fence, as is easy to do from the property where Rosa Lopez lives, or whether Detective Furman, who well could have and had the motive, and we say the opportunity, carried that glove, from where he found it at the crime scene and deposited it in a way that would accomplish 2 things. Number 1, it would keep him inexorably in the lawsuit. And number 2, it would punish a black man who had the temerity to associate with a white woman in a romantic way. Now, that's the theory of the case, and I think that the evidence that we're offering to support it ought not to be excluded. I think the question goes to the weight. If Detective Furman wants to say, the kinds of socks I wear are so fragile that they wouldn't have carried the package, that may be his answer. The question is, are we entitled to ask?
I think it could be both. And I know I'm starting in the middle of a conversation that I just had in my own head, but I'll catch you up. Don't worry. So he's saying that Furman was so racist that made him plant evidence. So OJ has to be innocent. The prosecution is stupidly saying he's not racist at all. And I'm saying it's both. I'm saying he is outstandingly racist. And he did not plant evidence. he's racist, but he did not plant evidence in this case because just doesn't make any sense whatsoever that, like I said, even if Mark Furman was very racist, picked up this glove, put it in that bag, like he said, and took it over to OJ's house and put it down. Even if he did that, how did the blood get in the get to OJ's car? I mean, did he also do that? Are they going to go to there too? Because there's just other evidence.
As to the letter, so I'm holding, I believe, does the court have a copy?
Yes.
All right. It is a letterhead specially made up for this case, and it says Mark Furman Justice Fund. It seeks financial contributions. And I respectfully suggest, Your Honor, that it's admissible for several reasons. First, Detective Furman knew about it, and it was to his financial advantage if others would pay his legal bills so that he wouldn't have to. Number two, unless and until Mr. Tortolo can provide some evidence that the expenses, not fees, but expenses of handling Mark Furman's representation in this case had caused him to spend $100,000 of his firm's money, as this says, then he has committed a rather neat violation of Title 18, Section 1341, mail fraud, by trying to induce people to pay money on the ground that $100,000 had been spent. And if Detective Furman knows how that money was spent in representing him, in this case by Tortolo and Butler, I think he should be able to tell us. And if he doesn't know, then he should tell us whether or not he ever questioned this assertion before this letter was put in the mail to his fellow police officers to induce them to depart with their hard-earned income. I think that would be fair cross-examination, and that is the basis for further questions about this letter.
All right. Ms. Clark, you want to address just the letter, please?
Only the letter?
Yes, that's the only thing that we haven't discussed.
Now that I finally read the letter, Your Honor, I'm really stumped as to the relevance. I cannot see how, I mean, counsel has already gone into the existence of the
It says that, I know you just lost sound for a second, but it says that my microphone is not on, but it looks on. Can you hear me? All right, you should be able to hear, oops, wrong button. Should be able to hear court.
give Detective Furman a financial interest in the case. This is supposedly to defray costs, but it's really gotten way off the end of the scale of relevance. What is the probative value for which it's been offered? I haven't even heard of a theory proffered by counsel that would make this relevant to Detective Furman's credibility. This is a letter drafted by his lawyer. He was aware that such a letter was drafted. He himself did not draft it. He himself received no money as a result of it. As a matter of fact, the understanding I have is that there has been no money received as a result of this letter. I think that there's simply no relevance to this. There shouldn't have been cross-examination. As a matter of fact, what the people would like to do is simply ask the court to strike the questions and answers that have already gone and pertain to this letter as irrelevant, and not admit this letter itself, which is the height of irrelevance. I don't see the probative value with respect to the testimony of Detective Furman.
All right. Thank you, counsel. All right. The issue before the court is what can counsel use with regards to these items for the cross-examination, continuing cross-examination of Detective Furman. There being no objection to the flashlight, the mag light, that will be allowed. Court will sustain the prosecution objection to the use of the gloves for this reason. The glove involved in this case is an extra large glove. Its specific bulk and dimension, as mentioned by the defense theory, is therefore critical to how it could be transported by Detective Furman, given his garments that particular evening, how he was dressed, and what means he had available to him. I will preliminarily allow the plastic bag, however, to be used if, Mr. Bailey, you can establish a foundation that a similar bag of similar size was available to Detective Furman in the homicide kit. And as to the letter, I'm going to reserve judgment on that. I would like to read it sentence by sentence, and I don't have the opportunity now. I'd like to at least proceed with what you have left with the jury.
That's fine, Your Honor. I take it you will go to 12 and perhaps be prepared to address these matters this afternoon if we're still going. All right, well, in the event I should conclude cross with the postponements that confront me, and redirect is begun because you wish to use the jury's time profitably, I would like, once you have ruled, to be able to come back and complete the cross.
Yes, as to this letter, this letter, correct.
Last matter, Your Honor, the letter that was furnished to me, and this may be a copying fault, is blurred on the line that recites the amount claimed to have been expended.
It does. It does on my copy as well.
Do we have a copy where the figure 100,000 is clearly shown?
Mr. Bailey, the copy delivered to me this morning in court, and
Can we agree it's 100,000, or should we get the original from?
let me make a call.
All right, well then, all the more reason to delay recross as to this issue.
It's over 100,000 of the exact words.
All right, well, let's get a clean copy of this.
Thank you, John. All right, guys, I went way over. I went way over. I'm starting my whole week behind the 8 ball now because courts opened 23 minutes ago, and I'm still in my live stream. All right, I just got sucked in. I got sucked in. There was the glove, there was the blood, there was the money and the letter, and Marsha lost it. I'm going to make some shorts about what Marsha did today. I might even make a short little, like, 5 or 6 minute highlight video of what we did today and post that to show people what we saw today, because it was pretty good. It was a really good day. Thank you so much for coming out, guys. I really appreciate it. Yeah, it's Monday, so it's time to do laundry and clean the house and sleep a lot and get some quartz. Donald's gonna play with babies. Have a great day, guys. Thank you so much.